Today, the Court of Justice delivered an important judgment concerning the prohibition of discrimination on the grounds of ethnic origin under European Union law. The case arises from a Danish law on public housing, which provides for the reduction of the number of public housing units in so-called transformation areas. This classification depends, on the one hand, on socio-economic circumstances prevailing in these areas, for example, in terms of unemployment or crime rates, and on the other hand, on the fact that the majority of residents in these areas are, to quote the law literally, immigrants and their descendants from non-Western countries. The objective of reducing the number of public housing units under this law means that some residents of these neighborhoods have had or may have their leases terminated. Before the Danish court, they argue that the criterion related to the proportion of immigrants and their descendants from non-Western countries constitutes discrimination based on ethnic origin, which is prohibited under EU law. Asked about this matter by the National Court, the Court of Justice recalls that under EU law, ethnic origin is determined based on several factors, such as culture, language, religion, or living environment. Neither nationality nor the country of birth of a person or their parents alone is sufficient to conclude that someone belongs to a particular ethnic group. The court then establishes a clear roadmap for the national court to assess whether a criterion set out in national legislation violates the prohibition of direct or indirect discrimination on the grounds of ethnic origin under EU law. To determine whether direct discrimination exists, the Danish court must first examine whether the criterion set out in the national legislation results in differential treatment based on ethnic origin, as defined under EU law. The court provides several key clarifications in this respect, including the fact that the criterion can be considered directly discriminatory even if the difference in treatment it produces concerns not just one, but several ethnic origins. If such direct discrimination is found, the national court must then verify whether this differential treatment results in residents of the transformation areas being treated less favorably than residents of other comparable areas. In this regard, the court provides guidance on how the national court should proceed. For example, the national court may take into account the fact that residents of the transformation areas appear more likely to have their leases terminated and consequently to lose their housing. The national court may also examine whether certain concepts used in the Danish law on public housing, including certain statements contained in preparatory documents, suggest that the law is based on stereotypes concerning immigrants and their descendants from non-Western countries. If so, the law could be offensive and stigmatizing, as it would contribute to perpetuating these same prejudices. If the national court concludes that there is no direct discrimination, it must ensure that the law does not establish indirect discrimination by creating a particular disadvantage for persons belonging to certain ethnic groups. To this end, the National Court must examine whether the law genuinely pursues an objective of general interest, such as social cohesion, and whether it respects the principle of proportionality. In doing so, the National Court must take into account, in particular, the fundamental right to respect for the home, as guaranteed by the Charter of Fundamental Rights of the European Union.